Welcome, everyone. My name is 𝐿𝐴𝐴, and I'm the co-director of the Center for Medical Ethics and Law here at the University of Hong Kong. So if you are in Hong Kong, good morning again, bright and early. But if you are elsewhere in the world, good day to you. For one of our speakers, Professor Cripps, joining us rather late at night, in fact, in the US. Wonderful to have you here with us, Professor Cripps. And of course, we will be listening to our colleague, Dr. Minsung Kim. But first of all, as we get started, we will be hearing from Dr. Hannah Kim. But before I introduce Dr. Kim, I'd like to invite all participants to consider whether you'd like to appear in our recording. If not, I'd encourage you to turn off your camera as well as your microphone. But please do keep your microphones off in any event if you're not speaking. We do have time for question and answer at the end of the session, and you're very welcome to present your questions or to otherwise interact with our very distinguished panel of speakers. So, so with this, we will get started in the interest of time. And some of you may have already been familiar with a number of these developments. So as you know, gene editing is an up-and-coming technology. Of course, the challenge on both the ethical and legal front would be to think about how best to address some of the many concerns that it presents. So, well, our first speaker, Dr. Hannah Kim, will be sharing with us the situation in South Korea, particularly in relation to the Bioethics and Safety Act. So, so this piece of legislation is highly innovative, and I think that South Korea is one of the first jurisdictions in East Asia to have such a legislation of this nature. So it'll be brilliant to hear from Dr. Kim in understanding what some of the developments are and what we can anticipate to follow in South Korea. So Dr. Kim is a wonderful colleague. You could see her illustrious CV in our webinar booklet. We have collaborated on many fronts, and it's always a pleasure, a great learning experience for me to hear Hannah speak. So Hannah, it's over to you. Thank you very much.
Thank you so much, Chair Kevin. My name is Hannah Kim, and it's my great honor to have an opportunity to presentation with this topic today. My title is Reconsidering the 14-Day Rule for Human Germline Genome Editing Research, and I will show some South Korean perspective to you today. So maybe some of you know what is the 14-day rule, but I think for other people, for other colleagues, so I will talk about the concept of the 14-day rule first, and then I would like to talk how South Korea adopts the rule by the Bioethics and Safety Act, and I will show you some very important constitutional court cases to you. And from the arguments, from the reasonings of the Constitutional Court cases, so I would like to talk about some logical paradox, how it makes some kind of conflicts to extend the 14-day rule and between the human right recognition in South Korea. Recently, our law has some revised, so I will provide some recent progress to you, and then I will finish my presentation to show some remaining challenges. All right. Okay. So let me start my presentation to provide the concept of the 14-day rule, and it refers legal and regulatory limits that prevents in vitro human embryonic research to the period before the primitive streak appears. And actually, primitive streak appears after 14 days fertilization. So the 14 days rule mean it's similar to the period before the primitive streak appears. And this rule appears, firstly appears from the Wano Committee report that is published in 1984, sorry. And I think it's important to understand the arguments noted in support the rule. First, 14 days is the last stage in development at which twinning can occur and therefore represents the point of individuation. So individuation was really important at the committee. And second one is not even the founding cells of the nervous system have been specified prior to this stage. Third, there is substantial embryo loss from the time of fertilization up to this point. And then the last one was until the process of the implantation is complete, the embryo has no potential for further development. So those arguments were adopted in various countries and South Korea as well. And the Wano report and the Wano committee suggested some recommendations for legal limits on human embryonic research at the time. So firstly, they focused on the authorized use. So the first recommendation was any unauthorized use of an in vitro human embryo would in itself constitute a criminal offense. A second recommendation is directly focused on the 14-day rule. It shall be a criminal offense to handle or to use as a research subject any live human embryo derived from IVF in vitro fertilization beyond that limit. And we can see another criminal offense provision recommendations. Any unlicensed use of trans-species fertilization involving human gametes should be a criminal offense. So those recommendations make some many issues, but today I would like to focus on the 14-day rule in regard to the human genome editing research. We had a very big science scandal in 2004, from 2004 to 2006, and after at some point like 2013 or 14, the issue was re-emerged, but actually the main point of the issue was related to stem cell research. And one of our Korean scientists announced that actually he published an article to Science journal, and he succeeded cloning, human cloning, and he succeeded to make a stem cell from his research. And then in 2006, Hwang Usok Hwang admitted he fabricated his research. Bioethics and Safety Act enacted in 2004 and implemented in 2005, and this scandal was affected to the enactment to the purpose of the Act, BSA. So that's why we adopted a 14-day rule in the Act. So you can, as you see, first of all, the BSA allows research using residual human embryo before the appearance of the primitive streak. And this provision directly adopts the 14-day rule. And secondly, a human embryonic researcher should be registered as a form of an embryonic research institute at the Ministry of Health and Welfare. And this provision emphasizes the authorized use of the human embryo. And then in the BSA, a human embryonic research proposal should be approved by both of the IRB and the Ministry of Health and Welfare. And at the time when the BSA was enacted, there were no clear role of the National Bioethics Committee for the human embryonic research. And from this law, the IRB role was emphasized, recognized for human social research, including human embryonic research. So the IRB means the IRB particularly for human embryonic research. And there are some sanctions that you see, like criminal offense. But after the enactment of BSA, there was some constitutional court cases. And why I would like to share our constitutional approach is this constitution and the court cases made some further arguments, further discussion based on the 14-day rule. So first of all, there is no clear mentioning for the right to life in our constitution, but in Article 10, the constitution assures the sanctity of human life and the dignity of all citizens, and it also confirms the duty of the state to confirm and guarantee the fundamental and inviolable human rights. And the right to life is stipulated in several times in some constitutional court cases. Actually, firstly, the right to life is appeared in 1996 case regarding the capital punishment. But after that, the BSA was enacted, and then it is affected to the 2009 case on stillborn fetus's right to claim for damages. Briefly, in this case, the court concluded that the right to life is applicable to human live fetus because in whole developmental period, the human live fetus is regarded to possess the human rights. And this case is also affected to 2000 constitutional case on bioethics regarding embryonic, human embryonic research. And in the case, the court concluded that the right to life is not applicable to a human embryo in vitro or before the appearance of embryological primitive streaks. And in the case, several questions presented, and one of the questions was focused on whether all human embryos possesses human rights. And I brought the summary of the case, the conclusion in the case. So a developmental prenatal life can be regarded as possessing fundamental rights when constitutional protection for the life is highly required and the case meets a certain standard. However, So from this sentence, they presented some reasons why the right to life is rejected to early human embryos. First reason was that it is hard to affirm the continuity of the entirety from embryo to an independent human being unless they are implanted into mother's uterus, where the embryological primitivity appears. And secondly, the court emphasized the contemporary level of technological development. So given the contemporary level of technological development, an embryo is expected to develop into a human entity only after being implanted into woman's uterus. And the last one was that there seems to be no social recognition that such early human embryos are regarded or should be treated as human entities. And actually this paragraph is not focusing on why they suffer the 14-day rule. It is focused on why they are rejected the early human embryo possesses human rights. But I think those paragraph is really important to revisit 14-day rule in South Korea. So maybe some of you know the recent scientific breakthroughs in surrounding the human germline genome editing research. So in ISSCR guidelines that is published in 2021, they mentioned some very important scientific achievements in vitro derived gametes. So they want to escape their research infringing humans' dignity. So first one was in vitro derived gametes, and secondly some organoids and embryo-like structure also very big, show some scientific achievements. And in the research, some scientists presented they can make embryo-like structure like or brain or heart escaping the fertilization, and it's like making arbitrary development way to make the embryo-like structure or organoids. And even there are some finding for the human-animal chimeras. So maybe those kind of scientific achievements show there are the evidence to extend the 14-day rule, but those category also show there are some the developmental capacity of the human embryo or kind of embryo-like entity is growing now. And secondly, our constitutional court focused on the possibility. There's our constitutional court focus was there's no possibility to develop human embryo in vitro after 14 days. But the in vitro embryo culture technique is also developed now. And in the last reason, to reject the embryo, whether embryo possesses human rights, humans' fundamental rights, was there's no social recognition. So social recognition is really important, but in different perspective, there is some growing societal value in promoting the research that may involve germline gene editing technique in human embryos or gametes prior to the stage of implantation in even in South Korea. So as the technology is changing and developed, our society's attitude and perception is also changing, and those scientific evidence are supported to extend the 14-day rule, but it is also based to the kind of conflict with our constitutional court's logics. So the logical underpinning of the 2010 constitutional court cases of South Korea was that a developmental prenatal life can be regarded as possessing fundamental rights when constitutional protection for the life is highly required and the case meets a certain standard. And this sentence were all applicable to fetus and human fetus and embryos. But actually, there's no mention of what is the certain standard and what is the point, what is the clear distinction between fetus and embryos. Actually, it's really a classic discussion point, but it's like we have to meet this classic discussion in recent future in South Korea. So extending the developmental limit of human embryo in vitro may meet a certain standard to be regarded an entity that has a growing potential as possessing fundamental rights. Actually, I think Professor Chris gave some idea for what is a human entity and what is not human entity currently and in the future. Maybe I guess, but and we face there's no normal standard of humanity, a human being. So maybe we can meet those questions in a recent future. So next, I would like to share our policy progress, our recent policy progress. There was some declaration from the Korean Academy and the National Bioethics Committee to revise BSA to facilitate the human germline genome editing research using human embryo. And so firstly, there was a prior revision of the BSA in 2006, but actually at the time, the provision was really ambiguous. So, but at the time, the genome editing scientists were really happy to see the revision of the bioethics, but as they found the provisions were very ambiguous, so that's why they stopped human germline genome editing research in South Korea. So after that, some very notable Korean scientists went to United States to continue his research using fresh human embryo, and he and his colleagues published an article to a very notable journal like Nature. But at the time and still and until now, using fresh embryo is prohibited in South Korea. But after that, after those sequences, in 2020, the BSA was revised for opening gene therapy research. So they didn't use the term genome editing research. They only they wanted to use gene therapy research, including genome editing research. So firstly, the law extends the scope of diseases that permit for gene therapy research. Firstly, research to treat genetic disease, cancer, AIDS, or other life-threatening or seriously disabling disease. And the second one was revised. Research to treat diseases for which there currently is no cure, or when the effect of gene therapy expects to outweigh those of other therapies. So there's no, limitation for the disease list for the second provision. So in any means, the revised BSA requires to submit the research proposal to the IRB, and stipulate the duty of the IRB to consult to the National Bioethics Committee in advance for the high-risk gene therapy research. So in the revised BSA reinforced the role of the IRB and of course on the role of the National Bioethics Committee to consult whether the IRB approved the high-risk gene therapy research or not. So what is different between the enactment time and now and the revised and 2020 revision of the BSA is the enacted when the BSA was enacted, the IRB role was just appeared, and during more than 15 years, the IRB was stabilized in South Korea, and there made some kind of association, Korean association for IRB, and they very actively developed the role of IRB and make some standard. And then at the first version of the BSA doesn't mention the role of National Bioethics Committee. The first version of the BSA only mentioned the role of the Minister of Health and Welfare. But in the recent revision, we found the role of the National Bioethics Committee rather than the role of the Ministry of Health and Welfare. So this is my final slide. It seems that South Korea slightly opens the back door to human germline genome editing research. But as you understand, as you see, there's no mention. Gene therapy research includes the genome editing research, but they categorize high-risk gene therapy research and low-risk gene therapy research. And for high-risk gene therapy research, the law reinforced the IRB and National Bioethics Committee's role. So, and so in the law, it is wondering. Some of scholars is wondering whether the modification of human germline cells in non-clinical research is allowed in South Korea or not. but it is interpreted to allow genome editing research categorized into a high risk high risk gene therapy research. So it's like opening door, but why the reason the law did not mention the genome editing research is because of the negative attitude or some negative attitude from the society. So they want the lawmakers, I think the lawmakers wanted to escape the kind of conflicts to revise the BSA at the time. And the second point is about the criminalization and or self-regulatory mechanism. So maybe I think the revised BSA does not provide a clear direction whether criminal bans or criminal sanction as a suboptimal inflexible policy for science are not a suitable instrument to regulate human embryonic research, because even though the revised BSA adopted the I'm sorry. Adopted the role of the IRB and the National Bioethics Committee. They didn't mention the specific role between the IRB and the National Bioethics Committee. And I think we need the accumulated cases are needed to facilitate the communication between IRB and the National Bioethics Committee. And maybe that kind of communication and accumulated cases make the better self-regulatory mechanism, but the revised BSA did not delete the criminal sanctions. So it is confusing. It makes some confusion whether the revised BSA emphasize self-regulatory mechanism or not. I think it's like we go together. I think we go together, but in recent future, maybe the BSA should be revised again. And the next point is about the certain standard that is mentioned in the Constitutional Court cases in 2010. I think a certain standard during the development of prenatal life that needs constitutional protection is unanswered. It should be answered, and maybe, but actually recently, a few years ago, in Chinese scientists announced that the gene edited twins were born. So maybe they kind of what is prenatal life needs constitutional protection, human rights protection is needs intensive discussion in South Korea. But I think this kind of discussion is stopped after the revision of BSA in 2020. And my last point is about human rights, the weakened human right path in South Korea. So my previous slide, in this slide, I emphasized the social value is changing. It's getting changed in promoting the genome research, because genome editing research, because the kind of scientific achievement can make benefits for all citizens. And this is the concept of the right to science. But actually, as why I mentioned just right to life is right to life is mentioned in the constitutional court cases, and there and we also can find right to health, right to sex, right to health in the constitution, but the Constitution of Korea is not adopted right to science. And the right to, in the right to science, the benefits for all citizens from the scientific achievement is the key concept. So, and we even though we rectified to the ICSCR, so right to science is not is under highlighted yet. So and BSA, the BSA starts from the human dignity approach. So maybe we will have some struggle to find our way to solve that kind of to extend the 14-day rule between the human right path and human dignity path. Sometimes it's really similar, but sometimes it's different. So thank you for your attention.
Okay, thank you so much, Dr. Hannah Kim, for the very rich presentation. So I myself have got lots of questions, so we could save that for the end. Well, since we have some time reserved then for general discussion. But perhaps just to have a bit of an appetizer, as it were, right? Some things to consider. So Hannah, as you know, I think at one of our meetings, which involved Jonathan Montgomery from UCL. So when he was chair of the Nephew Council on Bioethics, quite interestingly, they considered the prospect of reducing the 14-day rule to to 7. So it's interesting to hear that quite the opposite is being considered in South Korea. And I do wonder, looking at the science, if that makes sense, given that we are, as you've mentioned, on the front of organoid research, right? We're now able to develop an almost fully vascularized neurological system in a test tube of sorts, in an artificial environment, essentially. So it'd be interesting to think about what conception of life might mean in that sort of context. And I do believe Professor Cripps might be speaking a bit more to that, but more in relation to chimeric research in a bit. But I thought perhaps this is one issue that we could revisit in Q&A. I think it's still a very live issue, as I've mentioned, particularly because of organoid research. And of course, we see human-animal combination of sorts on that front as well. And you've mentioned very interestingly about the BSA and some of the changes. So it's fascinating to think that human genomic modification, well, if I understood your presentation correctly, it's not strictly prohibited. So, and you mentioned that IRB is essentially left with the very difficult job of risk evaluation. So, so I think that's fascinating because, of course, as we see in the literature, some scholars have argued that it's somewhat passé looking at the science to talk about moratorium. It's useless to say moratorium now because the science has moved on very quickly. Perhaps we need to actively engage with the technology, and that seems to, well, reading between the lines, be reflected in the Nephew Council's more recent report on the committee that's being chaired by, that was chaired by Jackie Scully. And then also quite recently, the report of the National Academy of Sciences in the US. So I thought with this, so some things to look forward to in discussion, but it's a great segue to move to our next presenter. Thank you so much again, Dr. Hannah Kim. I should mention that Hannah is one of our very special colleagues who's trained in both medicine and law. There are not many of such individuals, so able to speak in both capacities. But now we're going to move more towards the legal front, and that's to hear from our present colleague at 𝐻KU, Dr. Minsung Kim, who will be speaking exactly on this point on human genetic modification, particularly in relation to this well, relatively easy to use tool of CRISPR-Cas9. So with this, Minsung, is over to you. Thank you very much.
Oh, hi. This is Minsung, and thanks to Kevin. Yeah, I can present my recent research. I got the offer, the publication in South Korea, the Medicine and Law Journal. So, but I didn't complete the publication process. So, through this Zoom webinar, so I think I can a little bit more refine my paper after this webinar. So, I share the presentation, and yeah. The most of all, I want to introduce the uses of the CRISPR-Cas9. Currently, the uses of the gene editing technologies. In South Korea, and this technology cannot. I think internationally cannot be used for gene therapy directly applied to the human beings. But however, the uses of it other than the gene therapy increases the many benefits, such as the productivity of crops, and it preserves endangered species. But this presentation suggests the question, how about research on embryos and gene therapy? It depends on each of jurisdiction, as the Kevin introduced before the introduction section. In South Korea, the Professor Kim said, like, the researchers can conduct the research on gene therapy. As she introduced, the South Korean Bioethics and Safety Act was amended just last year to ease the standard of this research. Yeah, I briefly introduced why. Even though in Korea there is a 14 days rule, but nowadays internationally many bioethics concerns about these technologies, because normally the embryos was created only one egg and one sperm, but nowadays some scientists introduced two sperms, one egg technology, because this embryo, the trio pro nucleo zygote, the embryo is very similar with the first early stage of individuation, but these embryos never be human beings. So many scientists and researchers use these types of technologies. So I think the most important thing is how to control these types of research. So I think in South Korea, as the Bioethics and Safety Act, BSA, was amended the last year to ease the standard of the genetic research. So the committee needs to, I think the committee needs to play a critical role in encouraging the researchers, scientists to have a sense of responsibility for research on gene therapy through the process of governance. Specifically, the committee reviews the research, supervises, educated, and manages the research and the researchers. The question for my research is, when a researcher conducts research on gene therapy with embryos applied to CRISPR-Cas9, how the process of governance reasonably prevents the abuses of CRISPR-Cas9. Before the review the process of governance, I briefly introduced the definition of governance. most of all, the definition of governance has not yet been settled because a lot of area, the governance can be referred as a different meaning. But in this presentation, the governance is referred as the process controlling, directing, shaping, or regulating critical matters. And also there are many types of the governance process. For example, market governance, participative governance, flexible governance, and deregulated governance. In this presentation, I use the governance as a participative one in light of interdisciplinary studies. Yeah, so the governance for CRISPR-Cas9, the process of governance operates how to promote researchers' responsibility for research on gene therapy. I will explain, but shortly, briefly, the Professor Kim also introduced the abuses of CRISPR-Cas9 in China. So the 𝐁𝐫𝐲𝐞, he abuses this technology. But I think that we need to think about how to control and encourage the researchers' the responsibility. So I reviewed the principles for the governance, most of all, of human genome editing suggested by NASEM in US, the National Academies of Science, Engineering, and Medicine, in controlling the uses of CRISPR-Cas9. I think that these principles are very similar with the classical biomedical ethics articulated by Professor Tom Beauchamp, because he suggested the bioethics the basic standard should be the respect for autonomy, beneficence, non-maleficence, and justice. Based on his theory, I reviewed these principles of the governance suggested last year. The first, promoting well-being, transparency, due care, responsible science, respect for persons, fairness, and transnational cooperation. Those 7 principles, I think, specifically articulated the Professor Beauchamp's the classical biomedical ethics. I think about the principle is very ambiguous, but how these principles can be emphasized through governance. I think we need to consider how we can keep making a balancing between scientific values and universal values. I mean, for example, the Dr. 𝐁𝐫𝐲𝐞, the way on the scientific values only. So, for example, scientific values is like independence, ambition, and objectivity. On the other hand, the universal values like the peace, compassion, humility, and altruism. Like the NASEM, the WHO also last year suggested the principles about which research does not violate the universal values. So research should be like specifically accountability, transparency, responsiveness, adherence to the rule of law, stability, equity, and inclusiveness, empowerment, and broad-based participation. I think that the principle suggested by WHO is also like specifically articulated the Professor Beauchamp's the classical biomedical ethics, but even though I think those principles suggested by WHO and NASEM also not specifically what directed how to research the CRISPR-Cas9. So, but the WHO explained why they were not articulate a specific direction because of the developmental speed of the gene editing technologies. In light of the principles suggested by NASEM and the WHO, those principles implied the South Korea and the committee. I think the most important principles are accountability and the transparency. As I briefly introduced the Dr. 𝐏𝐫𝐸𝐻𝐾 case, those two principles should have been emphasized to prevent the abuses of CRISPR, because he didn't open his research, and he does not have also accountability to the future generation and his patient. So public participation and education and empowerment also should be emphasized to encourage the sense of responsibility based on each principles like the openness, transparency, honesty, and accountability. The South Korea, the committee determines which research on gene therapy using CRISPR-Cas9 can threaten the dignity of human beings and our community, or these research can contribute to benefiting us. So in sum, the South Korean committee should determine on the basis each of the principles, and to decide the researchers can conduct the research on gene therapy applied to CRISPR-Cas9. I suggest to the South Korean committee needs to consider three types of the researchers' responsibility, because the last year the South Korea government amended the Bioethics and the Safety Act. So, but as Professor Kim explained, specifically each of the article and the provisions are not specifically regulated which research can be allowed, which research can be prohibited, only decided by the committee. So, but the most important thing is, the researchers' fundamental attitude to their research. The researchers bears prudent vigilance in mind, and they have a sense of responsibility regardless of the law and the regulation. On the basis these fundamental attitude, my research articulated a researcher's responsibility, considering the three types of the researcher's responsibility. The first level is personal responsibility as a researcher. The second, responsibility for our community and transnational cooperation. And third, the responsibility for cooperating with all relevant people. The personal level is, when they used the CRISPR-Cas9 for their research, I think the personal responsibility is or the most basis the responsibility to the researchers. For example, the researcher, when they conduct their research, like the CRISPR, the editors, the bioethics. Yeah, so Professor Down, anyway, so she said when she did research about the CRISPR-Cas9, she didn't care a lot the bioethics because she was not the bioethics. So she just focused on her research. But when regardless of the ethics and the law perspective, the researchers fundamentally consider their research's ramification. Because the scientific values is also very important to the researchers, but without considering legal and ethical norms, I want to ask the bioethical researchers, what is the meaning of your research to our community, other than your personal achievement? So the second one is I emphasize the responsibility for acknowledging the governance I mentioned before, based on the principles and the committee, through the governance process, they directing, shaping, and so to acknowledging the governance, so the researchers should participate in the seminar and the public participation to follow the direction suggested by these types of the researchers, the community. The second, the responsibility is about they need to contribute to their community, and in light of the influence and the ramification of the CRISPR-Cas9, so they need to also cooperate transnationally. Researchers consider whether and how the result of their research can contribute human beings, community, and the environment. For example, considering the Dr. He's case, I mean not only the researchers focus on their research, absolutely that one is the fundamental purpose of the researchers, but also they think about the influence of their research on the community. For example, so I didn't put the South Korean, the Constitutional Court, the decision, because as the Professor Kim explained so well, briefly I added my comment about the South Korean Constitutional Court decision. In this case, the scholars and the relevant infertility couples, so they bring their case to the Constitutional Court. For example, the scholars argue to protect the human dignity, and they want, I mean they has the freedom of the research, but in the opposite side, the South Korean government opinion, they said the research is not will not threat the dignity of human beings, because the research only can be allowed the limited, I mean the designated embryos. So in this case, so the South Korean, the basic attitude to the research on gene therapy is positive, relatively positive. So I think the researchers has a freedom, have a freedom of the research. So they should be a responsibility for openly discussing the research on gene therapy. Dr. He didn't open his research, even though he presented his research in public, but he didn't open everything to the public. So to prevent the irresponsible researchers from abusing the technology, the governance process should emphasize the open discussion among the bioethical researchers. So I mean the theory of distributed justice is a huge issue, but I briefly mentioned about the distributed justice. We need to think about also including the researchers and the law scholar and the physicians. They cooperated interdisciplinary studies, how limited resources and the benefits can be distributed. As I mentioned before, the CRISPR technology increases the quality of human life, because we don't need to worry about the starving we don't need to worry about the extinction of the specific species. So, but we need to share these benefits with all human beings. So I think in light of the justice suggested by the Professor Tom Baucham, I think the governance process should consider the theory of distributed justice. Therefore, the researcher should actively communicate with the people who can be potentially influenced by his or her research. I mean, the influence of ramifications of the research on gene therapy applied to CRISPR-Cas9, we cannot exactly anticipate the result because of the off-target effect. So in light of the off-target effect, we need to consider how to keep a diversity of human beings also. Yeah, my third, the last, suggested responsibility for the researchers. I mean, they need to cooperating with all relevant people. I mean, the treatment, I mean, gene therapy is not only for the patients. I mean, as they received the gene therapy, they have their children, and these types of children also can be influenced by gene therapy and the future generations. We need to think about how researchers and the scientists prevent out of the ramifications, the boundary. The ramification of the research on gene therapy should be regarded as the subject of the interdisciplinary studies. The researchers, legal scholars, and the physicians and the medical ethicals, and even the religious experts also need to cooperate how to shape the regulating process through the governance. And the first of time I consider how to consider different cultural background and different ethics, because in European country, the American, Asia, all these types of countries has their own perspective and cultures ethics. So I focus on the universal value, even though we live the different background, different culture, but nobody can deny the universal values like the compassion, altruism. Even the different religions cannot deny the universal values. So I think based on the universal values, we need to keep going, discussing the development of the governance process. Lastly, I think the researchers, even though the Professor Tom Baucham does not want to weigh on some one of the principles other than the three types of, but I think the respect for all relevant people's autonomy is the most fundamental principles other than three types of the principles. Those who participate in the research on gene therapy, or even though not the gene therapy is prohibited strictly, maybe in the future or later, will receive the gene therapy because, for example, mitochondrial replacement therapy was not allowed to apply to the human beings, but we did it, and I think gene therapy also sooner or later will be applied to the human beings. So we also think about the dignity of the future generations, because Dr. Ho's research, maybe the twins' name is Lulu and so we need to consider their right also, because they cannot choose anything before, because they are just embryo, and when they are born, oh, my gene was edited by my parents. So the researchers and the infertility, for example, infertility couples seriously consider the future generation, and also the committee, the South Korean committee, also consider how to keep the dignity of the future generations. Yep, thank you so much.
Okay, thank you so much, Minsung, for the wonderful presentation. Well, I think what Minsung has shared with us, the point on involving the community and people more generally, is an extremely important one. So as Minsung has mentioned, in relation to the Dr. 𝐏𝐫𝐸𝐨𝐾 incident on mainland China, so some of you may have seen the proposal. It was reported in Nature. Proposal being made by our colleagues on the mainland, Professor Tu Renzong in Beijing and Professor 𝐊𝐨𝐫𝐸𝐻 in Wuhan. So they have recommended that given that there are now 3 girls born out of the Dr. 𝐏𝐫𝐸𝐾 incident, there ought to be some responsibility on the part of the community to ensure the well-being of these 3 children. So that's where you'd see the communal element coming in. But I think it raises some very interesting issues in thinking about how regulation for that matter, of course, typically, involving rather rigorous monitoring and evaluation, particularly within a clinical trial kind of setting, could apply to this sort of technology. And given what we've seen by way of the consequences and some of the other developments that followed the Dr. 𝐏𝐫𝐸𝐾 incident, how do we then think about the moratorium? And if we are to move away from the moratorium, then returning to Dr. Hannah Kim's point, how then do we think about reconciling some of the potentially competing principles? As she's mentioned 2 of them, the right to science and human dignity. So that's something that we may want to take up in discussion after we hear from our final speaker, last but not least, Professor Yvonne Cripps, because I've had the great privilege of having studied under Professor Cripps that's some years back. And so it's wonderful to be reconnected here, this great opportunity to hear her again on a very important topic. And of course, human-animal combinations, chimeric research with a lot of course, ethical as well as legal implications on how we think about personhood and human dignity. So with this, it is over to you, Professor Cripps. Thank you very much.
Thank you very much, Calvin, and good morning, everybody. It's a great honor to be invited to speak alongside Professor Kim and Dr. Minsung Kim, and I'm glad to do that. I'd like to pick up precisely, if I may, where they left off and to talk about Dr. He and what happened with his work in China in 2018. Professor Kim mentioned in her wonderful presentation the concept of germline modification. It appeared towards the end of Professor Kim's talk, and I'd like to focus in on that because it's a particularly important facet. And without getting into too much technical detail, the distinction that is key is between germline modification of a human being or other creature and somatic modification. So if you modify a human being somatically as opposed to germline, the modification will not be passed on to future generations. Now, this point of scientific interest is also reflected in legal documents as far back as 1998. For example, in the European Union's directive on patenting Biotech Inventions, Biotechnological Inventions, 1998, a distinction is specifically drawn between granting patents on genetic modification of human beings, which is in general permissible, but what is prohibited in that international treaty is the patenting of germline processes for modifying human beings. Now, why, you may ask, would the European Parliament be concerned about this scientific distinction between germline and somatic modification of human beings? It is not only that any modification germline is passed on to future generations and thus affects the human gene pool, it is also that any such modification affects more than one characteristic. So when we modify a human being, let me give the example of sickle cell anemia, which I'm sure Professor Kim, with which you'll be very familiar. It occurs predominantly around the Mediterranean regions, North Africa and so forth, and other parts of the Mediterranean. Now, I mentioned that example because it's a genetically transmitted illness, sickle cell. But if you have sickle cell, if you have that gene and those proteins coding for that, they also, the very self-same proteins, code to confer protection against malaria. So if you made a modification, a gene therapy to an individual, and you accidentally cut out other characteristics that that gene codes for, that protein codes for, it would be less of an accident, less of a serious problem than if that modification was done germline, which means it would be passed on to the descendants of the modified individual and thus into the human gene pool. So it's really a very important distinction. Now, if we look at the US, modification of human beings in gene therapy has already taken place. And alarmingly, it took place even before the more refined CRISPR version of genetic modification or genetic engineering. For instance, in the case of a young man, in fact, a teenager called Jesse Gelsinger, gene therapy by genetic modification was applied to him, fortunately not germline, but just somatically to modify him, not to his reproductive cells. And it didn't go well. It was a less refined version of genetic modification than CRISPR is. And unfortunately, the young man died. But of course, knowledge of that incident and other attempts abroad at gene therapy have focused the attention of the international community. And then we come, as both our excellent presenters have done, to the case of Dr. He in China, the 2018 incident. Now, as has been referred to, he modified 3 embryos. Now, twins and another embryo. What is really significant in that is the word embryo, because that immediately tells us scientifically that this was a germline modification, because what you do to an embryo, the way you modify it, will be passed on to any descendants of those 3 now born babies. So it's very significant that what Dr. He did was on embryos rather than babies or adults, because we know that because it was done on embryos, it is germline and thus able to be passed on. So that was made his lack of transparency in terms of Dr. Kim Minsung's excellent presentation all the more egregious. It was a striking intervention, not just a somatic one on those individual babies, but an intervention, genetic modification that would be passed on to their descendants. So I just thought I'd emphasize those points. And Hannah, Professor Kim also mentioned in her presentation an incident in 2006 in South Korea, where a doctor claimed to have cloned human beings. There was also another claim by Dr. Antinori in Italy that he had cloned human beings. But the interesting thing about that is that whether or not that Korean researcher actually did clone human beings, we do know that scientifically human cloning has been possible since 1991. Now I'm going back a long way, and that will seem very striking to anyone listening to this presentation, because there I refer to one of the two possible types of human cloning. And again, I think this is a very important distinction. The type of human cloning that became scientifically possible because of a breakthrough in the early 1990s is the type of human cloning that is done by what is called embryo splitting, where you literally, usually in the course of in vitro fertilization work, in a laboratory, you take an embryo, you literally, in fact, shake it until it divides into two parts, which then reproduce, which double, redouble on their own. So you take a single embryo and mechanically, as it were, turn it into two. That's cloning by embryo splitting. It's been very common in vitro fertilization laboratories and clinics ever since the early 1990s. Now, the type of cloning to which the Korean researcher referred and claimed that he had done was the type of cloning that you may have read about with Dolly the sheep, which is not by embryo splitting, but by somatic cell nuclear transfer. So you take a somatic cell, you knock the nucleus out, you transfer over the nucleus from the creature that you're cloning, and then you implant it into a surrogate mother and the embryo comes to term. That type of cloning, which we could call the Dolly method of cloning, is much more scientifically and in terms of social consequence dramatic than the embryo splitting, because if you're cloning someone from a somatic cell rather than a reproductive or germline cell, you don't need even a reproductive entity of fertile age. So you can take a somatic cell, for example, from an adult male, and using the Dolly method of cloning, you can produce a cloned human being from that. So there's this distinction, again, revolving around the difference between somatic cells and germline or reproductive cells. The somatic cells are simply all the cells in the body which are not, broadly speaking, not the reproductive cells. So you can clone an entity from what might be a skin cell if you use the Dolly method of cloning, whereas that embryo, that older method, an in vitro fertilization laboratories, where you just split an embryo apart. So you've deliberately created identical twins in the way that nature sometimes accidentally or in the course of nature splits an embryo apart in the womb and you get identical twins. That earlier that earlier embryo splitting method is much less controversial because you had to start with what you might call a conventional embryo produced from two parents in the conventional way, whereas this other method that the Korean researcher claimed to have done in 2006 is what we call the Dolly method, from Dolly the sheep, who was the first mammal to be cloned by that somatic cell nuclear transfer method. That other method didn't require a germline cell, a reproductive cell or a fertile cell from an entity of reproductive age in order to do the cloning. So I think these are really significant distinctions which we can come back to in the questioning. Obviously, if you don't need an entity of reproductive age to clone from, you have dramatic social and demographic consequences, because women, for example, don't need to be of fertile reproductive age. And someone of migrate age could have this somatic cell from skin cell method applied to clone them. And equally, as I mentioned a moment ago, a man could be cloned in that way. Whereas for that other method of embryo splitting, obviously you need reproductive entities. It's conventional reproduction, and then the embryo just splits apart, although it's done deliberately rather than in the natural way that natural identical twins would occur. So then I come to other issues in terms of the excellent presentations given by Hannah and Minsung. We talk about regulation of this field and of genetic modification of human beings by CRISPR or otherwise, those earlier, cruder techniques that proved so unfortunate for 𝐏𝐫𝐸𝐭𝐢𝐳, that American teenager. But we think of how we might regulate those. Now, in the US, there's a very big regulatory distinction between the public and the private sector. And even the public sector, such work is mainly controlled or regulated by the withholding of public funding, of public money to do the research, to do the work. But of course, that leaves open a vast field where the private sector is involved and anyone not relying on public sector funding, which is most of the private sector. So if I may crudely use the term, it's a bit of a Wild West in America in terms of control and regulation of this kind of thing, with very little control indeed in the private sector, and the control in the public sector being mainly through the IRBs, that if you put forward a proposal in the public sector, you probably won't get public funding if there was to be, for example, modification of a human embryo before 14 days. Query what is the position in the private sector where it's really unregulated. Now, interestingly, I think most American legal analysis of the question of what can be done on or in relation to human beings occurs in the context mainly, and firstly, I'll come to the second one in a moment, of patent law. who would have thought that it is the patent lawyers who have first considered these issues? I've already mentioned that in Europe, it was as far back as 1998 that the European Parliament passed that directive which prohibited patents on processes for the germline as opposed to somatic modification of human beings. In other words, again, focused on what would be passed on, inherited. More recently, in the United States, the US Patent and Trademark Office has been called upon to consider these issues. A US developmental biologist by the name of Stuart Newman put an application to the USPTO based on his work, this was many years ago now, on chimeras. And what he was doing as a developmental biologist was creating frogs which had been genetically modified by him to be headless in terms of not having the cerebral cortex that had been genetically engineered out. But because these frogs still had the lower brain, the brain stem, they continued to breathe. So these frogs were living on, just that they didn't have the higher brain functions. Now, why on earth would Stuart Newman want to be working on that anyway? Well, he was working on it as a kind of bioethicist as well as a scientist, because what he was arguing was, if I can modify creatures, if we in general can modify creatures so that they don't have the higher brain functions, but they still live and breathe, would we regard those entities as proper frogs, or more importantly for our purposes and his, proper human beings? In other words, he was saying, I give you the headless, the modified, not headless, but cerebraless frog as a source of spare parts. So he is asking, what are the moral implications of using such a creature, especially if it's a human creature, which we could modify in that way, as sources of spare parts? The argument being, well, they don't have higher brain function at all. They're just sort of, they're like vegetables. And we've addressed those issues in law in every country where a person tragically has a road accident and ends up on a ventilator, but without any higher brain function. And variously in different jurisdictions, we may be declaring them to be dead and then taking their organs for transplant. So he was saying, well, I give you the modified entity. Can we use it for spare parts? Now, he took this one whole step further by putting an application to the US Patent Office and saying, and I want to patent creatures thus modified. And he didn't limit the patent application to frogs. He limited it to all sorts of other creatures, including chimeric ones. And the Patent Office was then asked to rule, the US Patent Office, on whether such a chimera, if we focus in, he particularly did one of his claims in one of his patent applications was on a human mouse chimera, which was a mixture of mouse and human cells. So a chimera in that sense, a sort of cross-species creature that he and others were creating. Now, the Patent Office decided to rule on this, although it needn't have, because it was in a way, it was kind of moot, but it gave a statement. And to summarize, the gist of that was, well, we would consider patenting such a creature if, now they didn't expressly use 50%, as a percentage, as a number, if it is less human than not. If it is more human than not, by which I would read 51% human, we would not patent it because we would not patent a human entity that would be unconstitutional. So that brings in our second legal arena in which these issues have been discussed, which is constitutional law. So just dwelling for a moment on that patent point, the US responded to all this a little bit later, in fact in 2011, with the America Invents Act, particularly Section 33A, which I've written about all this elsewhere. Now in Section 33A of the America Invents Act, and I'll just read you the relevant words, no patent, this is a direct quote, no patent may issue on a claim directed to or encompassing a human organism. Now I'm sure you all are thinking, not terribly helpful, because what is a human organism? And unfortunately, the Act, which is a patent statute of 2011, does not define human organism. So we turn to the Constitution. I predict that provision will be a very fertile source of litigation going forward as people try to decide what is a human organism. Note that the drafters of that provision avoided the more obvious, which appears in other statutes, usage of human being or person. Human organism was, I think, deliberately vaguer, maybe to cover things, of course, like chimeras. Human being and person, which appear in other statutes, are avoided in this particular statute. So no doubt the courts will be asked to interpret. Now, continuing in the patent law vein, a case on Dolly the sheep, that was the world's first mammal to be created by that method of cloning, which is not the easy embryo splitting one that's been around since the 1990s, but that more dramatic method of cloning. So the patents, and there were 53 of them, on Dolly the sheep by the Roslin Institute in Scotland in the United Kingdom, came before patent offices all around the world. And in the US proceeding, which I think was the most interesting because it went on appeal to the US Circuit Court of Appeals, one level below the Supreme Court. I really regret that it didn't make it to the Supreme Court, but still to the second highest court in the land on appeal, on the fascinating question of whether a clone of whatever type, whether a clone could be sufficiently novel for a patent under patent law. Because of course you'll all be thinking the essence of a patent is that it's over something novel. It's not like a clone, which at the very least is arguably extremely similar to the entity that was cloned, the creature that was cloned. Now, to cut a long story short about that litigation, the judges decided on appeal that no, they thought, but they're not scientists, unfortunately. They said, well, look, it's a clone, it's identical, so it can't be novel for the purposes of patent law, patent denied. But those of us like Professor Kim with a scientific background understand that clones, even those produced by the embryo splitting method as opposed to the Dolly method of somatic cell nuclear transfer, are not identical to one another because of, for example, scientific features like epigenetics, where even within the womb, identical twins become epigenetically different. And of course, once they're born, the older these identical twins get, the more epigenetically they actually diverge over time. So one of the arguments raised by the Roslin Institute in Scotland in the course of that litigation. And I won't go into exactly why the court rejected it and how they got it wrong, arguably. But one of the arguments was, look, they're not identical. There's epigenetics, there's time delay, and various other features, which I won't, bore you all with today. But the court, being non-scientific, being lawyers, said, oh, no, look, it's clone, it's identical, therefore it's not novel under patent law. So we have to turn then to the constitutional issues, just as the US Patent Office had to do when Stuart Newman's human mouse chimera came before it, genetically modified chimera. And they said, well, look, it wouldn't be right under the Constitution. And one thinks then, although the Patent Office didn't really elaborate, but out of their wheelhouse, but a constitutional lawyer in the States would tell you that it could raise, and I've written about this elsewhere, 13th and 14th Amendment issues. The 14th Amendment relating to personhood, and the 13th Amendment relating to slavery and things of that kind. So for instance, if you were getting patent royalties off a human clone, there would be issues of slavery involved and profiting from their genetics and so on. But I don't want to go down that track today. I've written about that elsewhere. But for the purposes of today and the subject matter under discussion, the question then becomes for our regulations, what is a person? Now, of course, under the US Constitution, personhood has even been extended many years ago to inanimate objects like corporations. And I could go on and on about what else it might be extended to in the future. But for present purposes, is a human mouse, for example, chimera such as Stuart Newman and many others since have created rat humans, all sorts, and including tobacco humans, mixtures of plants and humans. Could they be persons for constitutional purposes? If they are, borrowing from the Patent Office, but looking at also in terms of constitutional law, more human than not, or to put the question another way, if I take a non-human animal like a mouse, or imagine something much closer to a human being like an orangutan, and orangutans, of course, have been granted personhood in certain countries constitutionally. But if we take something like an orangutan modified with human genes, research which is going on in several different countries, not to mention the rats with human genes going on, I've written about recently. In terms of personhood, the question then becomes, if the non-human animal like the rat or the orangutan is modified with enough human genes, when would they become a person? Conversely, if I take a human being and genetically modify it with the CRISPR techniques so that the human being becomes more pig-like, and they've been doing this. I was on a committee in Britain many years ago, decades ago, a Home Office committee, where we were overseeing experiments on animals. And we were overseeing herds of pigs which had been genetically modified, not to mention the chimpanzees, but herds of pigs which had been genetically modified to be more human-like, so that they could be sources of spare parts that wouldn't so easily be rejected when transplanted into human beings, because they would have more percentage of human genes, less likely to have the organ from the pig rejected. So folks, those are the issues which I'd like to put before you. I could obviously go on, but I'm mindful of the fact that we've left time for questions at the end. And often I think with such interesting presentations as Professor Kim and Dr. Kim have given, sometimes often in terms of the question that Professor Ho, that Calvin has questions that he has already asked, the most fun part is the question and answer. So I'll be quiet now.
Thank you so much, Professor Cripps, for the excellent presentation and certainly very helpful clarification on the science. So, well, making that very important distinction between somatic cell modification and germline genetic modification, as well as some of the technological distinguishing features. So with SCNT, somatic cell nuclear transfer, and its application for reproductive purposes or otherwise for therapeutic or towards therapeutic goals. So some very important distinctions to note as we move into discussion. I'd like to invite questions from the audience. So if you'd like to share your questions, you're welcome to unmute yourself and to present your questions. But just a reminder that if you do not wish to appear in our recording, or at least have your image recorded, you may just like to keep your camera on off mode, essentially. So any questions at all from the audience? While we wait, I'm curious as to what Professor Cripps would think of Irving Weisman's experiment. So a little bit different from Stuart Newman. So what Irving Weisman did when, as you may know, when he was at Stanford, was to create a mouse, essentially. So this would be a 𝐶𝐞-𝐄 mouse, so meaning an immunodeficient mouse, in itself an artificial construct through genetic modification. And he introduced human brain cells into the mouse so that the mouse would develop essentially with human brain cells. So I'm curious as to your thoughts. How are we to construe such a creature, given that, well, if we are to associate brain cells with human consciousness and sentience, that's a very human characteristic. Are we to consider such a creation a humanoid of some sort? Well, there are obviously some differences, but I do think it raised some rather interesting questions, and I see Hannah has got hands raised. Hannah, I wonder whether any such work is being done in Korea before we invite Professor Cripps to speak to this.
Yeah, I just add just one more point to Kevin's question. Actually, as I heard your presentation, your very wonderful presentation, I really appreciate it. I thought about the recent clinical trial to implant pig's heart to human who has patients, and it was a bit successful. And so, but we see him as a human being, but if we add some kind of pig genetic pig genes into the germline cell, then maybe I think your perspective is changed to like it'll be possible to not humanhood. So maybe your point is like a distinction between germline and somatic genetic modification. So I think it's kind of we need integrity, and we need integrity from different issues, different clinical development. So I just add just one point. So Yeah.
Thank you so much, Hannah. So Professor Cripps, it's over to
Yes,
you.
thank you.
I'd love to hear your thoughts.
Thank you for following up on Hannah's point that she just made there very interestingly. I think I wouldn't distinguish in terms of the very question of personhood from a constitutional perspective between, on that point as opposed to say patent law and other things, between the germline modified human and the somatically modified human, because when you look at the human, whether they've had pig cells introduced, whether somatically or germline that it would be passed to their descendants, I still think we would want to evaluate those individuals who had been modified with the pig cells, say, in terms of your example, in terms of themselves, regardless whether they deserve personhood, regardless of whether it was a germline or somatic modification. So I hope I didn't muddy the waters earlier.
Mm.
So, Hannah, I don't know.
Yeah, because developmental prenatal life is regarded to possess the human rights in South Korean constitutional court cases. But as you mentioned, there is no clear distinction between germline and somatic cell, right? I can recall your comments.
It depends on the context.
Yeah, it depends on context, but so maybe maybe we need one more point. Maybe we need to add one more point based on your presentation. We need to consider what is personhood, which kind of entity is considered to human entity or not. So we need a distinction in the future, but I think it's not unanswered. It's unanswered, right?
Yes, yes, and it goes to the point that Professor Ho-Calvin just also asked, and in relation to such things as chimeras. And in 2018, I wrote an article about this very point, about the rats and mice that had human brain cells engineered into them and injected into them. So these rats and mice had been genetically modified with human brain ganglion cells. What was really fascinating about that, Calvin, was that apart from all the legal dimensions, which we're considering here in terms of now personhood, was that the rats thus modified were even better at swimming through mazes than the unmodified rats. In other words, the ones that had the human brain cells injected were much better at tasks which required thinking, like getting through a maze and remembering how you got through it, remembering the contours of the maze. So actual human-like characteristics were to some extent observed, but yet this was in rats, in terms of the ones I described in my article, who had been only very, very slightly modified with human cells, a tiny percentage. I could, if it would help now, refer to the work of the scientists in this field, but I covered them in my article. There are some scientists who are particularly involved in this. But what's really interesting to me is that in those same laboratories, scientists who are also involved in developmental biology, and I quote one of them at length in my article, raise these concerns so that these concerns are being raised, being very specifically articulated as to when does it become sufficiently human to qualify as a person if you're modifying the rat, or vice versa, might it lose personhood at some point in the other direction, are being raised by scientists in these very laboratories that are undertaking this work. I suppose what they're doing is calling upon us lawyers to provide guidance.
Thank you so much, Professor Cripps. That's wonderful. So much to look forward to in terms of development, and certainly your writings to follow. I just wanted to take the opportunity to check back with the audience to see whether they've got any questions at all. You're very welcome to put it in the chat. Do have a question from Justin. Not sure if it's Justin who has been with us. Okay, so you may not see it, it's in the chat. He says that I have a question on the right to science and its relation to the right to health, something that Hannah mentioned in the Korean constitution, and it'll be, I think, wonderful to hear about whether the US constitution also speaks to this in any way. And he asked, I'm wondering if she could expand on the relationship, since obviously scientific knowledge has improved medical knowledge and outcomes, but the two are not necessarily or directly correlated. So, so Hannah, any thoughts? Relationship between right to science and the right to health, and of course, if you think about human rights more broadly, human dignity, as you've mentioned, and I'd love to hear from Professor Cripps as well in terms of the US position on this particular issue. Of course, in the US, I do not believe that there is any specific provision on the right to health, as I understand it, but I stand to be corrected on that. So Hannah, please.
Yeah, in our constitution, right to health is mentioned, and also right to creators is also mentioned. Yeah, to emphasize the scientists or the developers' right, but there's no mention for the right for citizens to enjoy the scientific to enjoy the benefits from the scientific achievement. I think right to health can include the kind of enjoyment of the benefits from the scientific bioscience achievement, but because we have the right to creators independently, and we don't mention the right to enjoy the benefits from the scientific achievements for all citizens. We don't mention the kind of rights. So maybe it's like we need more more efforts to try to balance between scientists and the citizens. And sometimes it's like that kind of research, such as gene editing research, or some very cutting edge science may not include, may not affect to health directly. So maybe it's like between clinical application and research and development. So so that's why I need to make a balance, where I need to highlight, we need to highlight the right to science in South Korea.
That's brilliant. We have Mr. Anthony Rogers. Is this a point that relates to Hannah's remarks?
Well, it relates more to what Yvonne was talking about. I used to be a patent lawyer in the old days, and now I'm fully retired. What interested me was why, I think it was in 1998, they allowed some patents and not others. And the reason is I can't quite understand why that should be so. Patents are used for, can be used for a number of things, not only to stop other people using your invention, but it's also a method of publication. And what that involves is, first of all, you publish your academic research. And the other thing is you can stop other people patenting what you're doing. You may not be concerned to stop or to get royalties or to stop other people doing it, but you may be concerned that you can carry on doing what you're doing, and your publication of your patent it ensures that nobody else can get a patent later. So the question I've got is, why were some patents allowed and not others? Is there a rational reason for that?
Well, Roger, thank you very much. I'm delighted by this question because it leads me into an area which I didn't think I had time for in my 25-minute slot, but which I find very interesting. When I worked many years at the University of Cambridge Law Faculty, I received a knock on the door unexpectedly from a scientific colleague who was representing Sir John Sulston. He was later knighted. It was just plain old Professor John Sulston at the time. Now, John Sulston was one of the European leaders of the sequencing of the human genome, the HUGO project, to sequence the entire human genome. And while John Sulston and his colleagues at the European Molecular Biology Laboratory based out of Cambridge were working on that, an American scientist called Craig Venter started systematically patenting the sequences as they were generated by his computer, because all the sequencing was being done by international teams who were really in competition with one another to get there first. But the sequences were sort of flying off computers. And the American scientist, Craig Venter, was applying for patents on each one, thousands of patents on each nucleotide gene sequence. And originally, several of these were granted by the US Patent Office. Now, even though the functions of those sequences were unknown, so in terms of patent law, that didn't meet the utility requirement, it later turned out, but they were initially granted by the USPTO, which was keen to have America be competitive in this, what was then emerging field of biotechnology. Now, why is this interesting in relation to your question about the purposes of patents and publication? Well, the representative of John Sulston, who was from the Cavendish Laboratory, the representative came to me and said, look, you're a lawyer, you're involved in this field. You must know how to stop this chap in America from getting patents on the unmodified, non-inventive, unmodified sequences of human genes. And well, as you'll know, Roger, it didn't take me long to say, yes, I know how we can stop that. And my answer was, why don't you all, you scientists, put up a publicly accessible website, which became the precursor of what's now called GenBank in the United States. Just put up a website open to anyone, free of charge, and you pump your sequences onto the computer. You publish these gene sequences as they come off the computer, and then they're in the public domain, so Craig Venter can't get patents. The laboratory in Cambridge did that, and the European team did that. And that is, in fact, the reason why only 20% of the human genome got patented. That is the unmodified human gene sequences. And the reason 20% was patented was because Craig Venter persuaded the USPTO to do it. Now, they later put out a statement saying they wouldn't grant any more of this kind anyway, because you had to express the functionality. You had to know the functionality of the sequence before, in patent lawyers' terms, you could claim utility. So I fully appreciate your point, therefore, about the effects of publication, but there are other ways of doing it than getting a patent, although I fully acknowledge that there were other instances in, for example, the University of Cambridge, with which I was familiar, whereby scientists were at personal loss potentially to themselves because they could have benefited financially, were getting patents on their inventions where they thought they were important for health improvements for the general public, getting patents so that they could not charge royalties, but prevent others from getting the patent and charging royalties. So I think going back to the European Parliament, they just wanted to make a statement, and indeed the whole of European patent law has a separate criterion of, is the patent contrary to public order and morality? And if I could give you an example borrowed from a British colleague, Philip Grubb, whose work you may know on patent law. Philip Grubb wrote, well, how do we define in European law the distinction between public order and morality? And he said, well, offending morality would be to have adultery, but offending public order would be to have or commit adultery in the public street. So that's public order and morality. So all European patents, and Europe is very broadly defined for patent law purposes, have to be not contrary to public order or morality. And so anyway, those are just some of the points that I raised in relation to your question. I think that the European Parliament was saying that a patent on a process of genetically modifying human beings in our present state of scientific knowledge would be contrary to public order and morality.
Thank you so much. That was wonderful, Professor Krebs. And
Yeah,
Anthony,
thank you very much.
thank you.
If I could briefly, just very briefly address Hannah's point.
Yes, please.
The distinction between right to science and right to life. I'm working here in the US at the moment, so looking at it from a US perspective. Exactly as you said, Calvin, the US Constitution does not specifically recognize a right to health. But in Article 1 of the Constitution, it recognizes that Congress has the power to encourage innovation. So there it is in Article 1, let's go for the innovation, it reads science. But nothing specific, that is nothing express about a right to health. But I argued in an article published, I was just trying to look it up just a moment ago, in a 2004 article, which was earlier than the 2018 one on the chimeras and personhood and rat human issues. But in an earlier article, I argued that you can read a right to health into the US Constitution through the 14th Amendment, which confers a right to life, liberty, and property. So what is life and liberty without health? So by a convoluted process of reasoning in the 2004 article, I argued that there's a right to health which the courts should recognize. And for that, I found support in cases like Skinner and Oklahoma and cases of that kind on constitutional law.
Well, that's brilliant. And of course, we see this space as highly politicized, as I understand it, in the US. And hence,
Yes.
I think a lot more discussion on this front to follow, especially with the midterm elections, isn't it, on the horizon?
Exactly, Kelvin. And only today, in fact, I caught some of the hearing for the latest Supreme Court Justice nominee, whom I very much hope will be selected, will be appointed, get through this congressional process, which is often very political. But they were grilling her on this question of unenumerated rights.
Thank you so much. Oh, I'm sorry. I think Professor Kim has to go because of a prior engagement. So thank you so much, Professor Hannah Kim, for being with us. Wonderful presentation.
Yes.
And I look forward to being in touch. Thank you, Hannah. So in the meantime, let me just ask if anybody has got any other questions for our wonderful panel. If not, then it's about 7 minutes past the hour. So I'd like to take this opportunity to thank our wonderful speakers, of course, Professor Yvonne Cripps, for staying up with us. It must be rather late in the US right now. Thank you so much. Yeah, we truly appreciate your time, and as always, it's a wonderful learning opportunity for me. And I'm delighted that we're able to connect this way through well, wonderful IT facilities right now, this day and age. And of course, to my colleague, Dr. Minsung Kim, thank you so much for the excellent presentation. A lot more work to follow, I'm sure, given developments in China concerning the 3 children that we've talked about. So I look forward to reading your paper on this as well. And finally, a note of thanks to my colleague, Ms. Jane Orr, who has helped to put all of this together, providing guidance to all the speakers and reaching out to all the various participants. So with this, have a restful night ahead, Professor Cripps, and a wonderful day ahead for everyone who's in this part of the world. Thank you so much again. And I shall be in touch, Professor Cripps and Dr. Kim. Thank you so much again.